Welcome to my YouTube session, students, on Civil Law 1 of Haryana Judiciary. Please confirm about the voice and the video. You can write in the chat box. Okay, very good evening, Abhishek Shukla. Okay, perfect. Okay, let everyone join and then I'll start within 2 minutes. Okay. Before that, if you want to ask anything specific, you may ask. Okay, I can read your comments as well. Fine. Actually, this is my first time that I'm live on YouTube for a YouTube lecture. So I'm super excited as well for that. Okay, students, so then now let's start this session. So I personally welcome each one of you on my first YouTube session on Civil Law 1 of Haryana Judiciary. So let's start with my brief introduction. My name is Sandeep Khatri and I'm born and brought up in Delhi. As far as my educational background is concerned, I have done my law from KC Law College, Mumbai, under University of Mumbai, and my LLM from Jindal Global Law School under OP Jindal Global University. By profession, I'm a teacher. I'm teaching law for more than 5 years now. And as you can see, these are my areas of specialization: constitutional law, criminal law, commercial law, family law, and law of torts. You can see, students, here, this is my profile on Unacademy. For all the updates about my special classes and my plus courses, you may follow my profile for that. And there is a Telegram channel as well. Any questions, and at any given point, if you have any question, any query regarding any of the subjects, or you are facing any difficulty while your judicial preparation, you can write your questions on this channel and I'll answer accordingly. In addition to that, students, I take suggestions from my students on which topic they usually want me to speak on in my special classes. This is my code KHATRILIVE, which you can use to get 10% discount in the plus courses. These are my some rules, students, that you need to be attentive. Do not miss anything. Okay, all the statements directly or indirectly from this class is going to help you in your judicial preparation, and this is going to be an interactive session. So I'm going to ask questions. Similarly, you are also going to ask questions, and we are going to communicate. So it is not like I'm the only one who is going to speak here, right? Okay. Very good evening, Durga Vyas. Okay. Very good evening, Atisha Jan. Okay. So let's continue. So what exactly you can expect from this series? So students, this is especially for the Haryana Judicial Services, but I'll make sure that this series is going to help you if you are preparing for Delhi Judiciary or for UP Judiciary as well. So what we are going to do, we are going to discuss the previous year questions, in addition to that, all the important questions and the concepts as well. For example, I'll start my class with asking questions, some PT questions, objective questions, and in that questions I'll help you to reach out how to solve objective questions. Fine. What are the concepts that are related to those questions? So we will focus on concept clarity as well, and at the end of every lecture I'm going to tell you all the list of important concepts or the section numbers for your exam. Very good evening, Premala Gupta. Okay. So the next slide is, students, the type of questions in your PT examination. Usually the questions are for section based questions. Fine. They are asking you what is section 2 has defined, or what is section 3, or they are asking you the concept. For example, where the term contract has been defined, right? So the first type of questions usually in your PT examination is the section based. The second type is your essential based, students, where they usually ask questions from the essentials of the section. So you need to remember the essentials. Then coming to the illustrations, yes, as far as your Indian Contract Act is concerned, or Indian Evidence Act is concerned, or Indian Penal Code, so there are a role of illustrations as well. Case laws, all the landmark judgments and the recent judgments as well. Then the maxims, and at last there may be questions from the application based. So I'll try my best that I'm going to cover all these sections of the questions in PT. Very good evening, Khushi. Very good evening, Madhvi Jha. Welcome everyone. Okay. So in this class, I'm picking the first subject, that is the Indian Contract Act 1872. Okay. So if you all are ready, just give me a thumbs up. So I'll come to the next slide, which is basically the questions. First, I'm going to ask you the questions, you are going to answer. Then I'm going to tell you the correct answer. And then in case if your answer is wrong, then where exactly you have committed the mistake. And this is how we are going to conduct this series. So just quickly give me a thumbs up so that I can see and continue with this class. Okay, students, wonderful. So here is the first question. Yes, please do answer in your comments. A very basic question. Okay, I have got answers. Okay, Abhishek Shukla has answered the section number as well. Okay, Durga Vyas. Abhishek Shukla. Okay. Okay, students, now I'm explaining the concept that has been involved in this question. So the question is basically, a proposal when accepted becomes what? So for that, I'm using my another screen. Just give me a second. So here I'm explaining the concept now. Okay, Madhvi. Okay. So the question was that if there is proposal plus acceptance, then what is going to be the result? The result is going to be the promise. Now the question is how I can conclude this concept. See, the term proposal has been defined in section 2A, students, and the term acceptance has been defined in 2B. And if there is a valid proposal and a valid acceptance, then as per section 2B of the Indian Contract Act 1872, it will become promise. So this is the first basic formula of your Indian Contract Act. Now continuing with this, the second formula which you need to remember, that is promise plus consideration. Now what is consideration? Where it is defined, you can write section 2D here, and if there is promise plus consideration, it will form a valid agreement. This is your section 2E. Now students, finally, if there is agreement plus section 10, or you can say enforceability by law, I'm writing in short EBL, that is enforceability by law or section 10, it will form to a valid contract. This is how you form a contract, and this has been defined under section 2 clause H. Now I am concluding this whole slide, students. We started with a basic proposal. Let's take a simple example. I give a proposal to Mr. B that I want to buy your house in 25 lakh rupees. This is a valid proposal under section 2A. And if Mr. B says, I accept your proposal, then as per to section 2B, that would be acceptance. And if there is proposal plus acceptance, it would amount to promise, which is under section 2 clause B. Now this promise plus consideration. Now what is consideration? I have given this proposal that I am going to buy your house in 25 lakh rupees. So that 25 lakh rupees is basically the consideration. Fine. Consideration that has some value in the eyes of law. So that is your section 2D, and it will amount to agreement. And if this agreement has all the essentials of section 10, let's take an example. If there is a free consent has been involved, fine. If the agreement is not with minor or with unsound mind, right? So in that case, it would, and if there is lawful consideration, if there is lawful object, it will amount to a valid contract under section 2 clause H. So if you can recall all this, if you can recall this chart, you can easily solve these questions. Fine. Any issues with this chart? Anyone? Yes, I'm waiting for your question. Anyone having any issue with this chart? This is basically, if I need to tell you, this is basically from section 1 to section 30. The conclusion. From section 1 to section 30. Yes. If it's all clear, just give me a thumbs up so that I'll move to the next question. Okay, Abhishek. Yes, what about others? If you have doubts, students, please do ask. This is your time. Okay. Fine. Many questions in your PT are going to be asked from this slide only. They are going to ask you, what if there is a promise and consideration? What will that amount to? Fine. Okay, I've got all the thumbs up and everyone is clear with this. Now I'm moving to the next concept. So a proposal when accepted becomes, the answer is your promise. Coming to the next question, students. Yes. Answer in your comments. Okay. Kushi has answered. Atishay Jain, okay. Okay, the picture is not clear. Okay, in case if the picture is not clear to you, I'm reading it. The question is, B's dog is lost. He advertised in a newspaper, and anyone who finds the dog will get a reward of rupees 10,000. Now this advertisement is A. a proposal, B. acceptance, C. invitation to proposal, and D. void agreement. Yes, Durga Vyas, if you can answer now. Actually, this was my first time, so I was not having that idea. So maybe from the next class onwards, you can easily read that. Okay. Most of the students has answered. Now I am coming to the concepts, students, that what actually the concept which you need to answer this question correctly. Okay. Now coming to this. Just give me a second. Okay. See, students, do remember this, that whenever they are asking you a question on advertisement, so I hope we all know what is advertisement. Advertisement is usually of two kinds. So basically advertisement, the purpose of advertisement is to give you information about the product. For example, if you are watching a YouTube video, so there's an option of skip ad, there are advertisements. Why? Because that company wants to tell you that we are offering this kind of a services or this kind of a product. Now, whenever there is an advertisement, it may amount to general offer, or it may also amount to invitation to offer. Now the question is, students, how do you get to know that which advertisement is talking about general offer and which advertisement is basically invitation to offer? Always do remember, students, if the advertisement is only giving you an information, everyone please be attentive, this is important. If the advertisement is giving you only the information, that's it, nothing more than that. If there is only information in the advertisement, it would be invitation to offer. Let me mark this. That would be invitation to offer. Let's take one simple example here. If there is an advertisement in the newspaper that they are selling a cream, if there is an advertisement in the newspaper that they are selling a cream in suppose 500 rupees. Now this is an advertisement which is giving you only information that this company XYZ company has came up with a new product that is a kind of a cream which they are selling in 500 rupees. So this is basically invitation to offer. Now coming to the second advertisement, what is general offer? Always do remember, students, when an advertisement is telling you to do something, then that would be concluded as a general offer. Now let's take one example. I hope everyone do remember the concept of Carlyle versus Carbolic Smoke Ball Company. In that case, students, what the company is doing, the company has came up with a medicine that if you are going to use our smoke bowls, then you will not longer be infected. And in that case, the Carlyle, the lady, got the medicine, which means that advertisement in Carlyle versus Carbolic Smoke Ball Company, they are not just giving an advertisement, they are also telling you to do something, which is to buy our medicine. And if you are going to be still infected, then we are going to give you 100 pounds. In that case, we will consider that as a general offer. Now students, in your comments, if you still have any doubt between the concept of general offer and invitation to offer, please do ask. Yes. Anyone who is still not clear with what is the difference or what is the meaning of general offer and invitation to offer, feel free. Okay. Yes, what about others? Okay. If you are having no doubt, then just do answer me this again. Yes, now. This question is also about advertisement, students. Now, what kind of advertisement we are dealing here? This is general offer or invitation to offer. Yes, now I want answers from each one of you. Because if you don't have any doubts, you can easily answer this now. What kind of advertisement this is? It's a general offer or invitation to offer? Okay. Correct answer, Durga Vyas. Now you got the concept. Yes, what about others? So the answer of this question, students, is A. This would be general offer. But obviously, as per to the options, the best suitable answer here is, that is A, which is proposal. I hope now you are learning that how to read the question, how to understand the question, and how to reach to the correct option. Chaliye. Now let's move to the next question, students. In case if you are not able to read it, I am reading it as well. The leading case of Carlyle versus Carbolic Smoke Bowl Company is related to what kind of an offer? Special offer, general offer, counter offer, or invitation to offer? The leading case of Carlyle versus Carbolic Smoke Ball Company is related to specific offer, general offer, counter offer, or invitation to offer. Okay. Now let me tell you the concept involved here. Okay. Students, when you are going to read proposal, there is one concept which you need to deal with it, that is the types. What are the types of proposal? And in types, students, these are the different types. First one is general offer. Second one is specific offer. third one is counter, and the last one is students cross. Now what is the meaning of this? General offer is something that is made to public at large. I'm repeating myself. General offer means that has been made to public at large. Okay, and now coming to the specific offer. Specific offer here means that has been made to a specific person, which means A made a proposal to Mr. B that I want to sell my house to you. In that circumstances, that would be considered as specific offer, which means only Mr. B can give acceptance. But when it comes to general offer, anyone, in this case, proposer has no idea that who is going to accept the offer. And this is the difference. General offer made to public at large, and specific offer to any specific person. Coming to the next thing, that is counter offer. So this is basically your bargaining, which means if you are going to give a proposal to a shopkeeper that you want to buy this t-shirt. In that case, students, your proposal may be suppose of 1000 rupees, but the seller says no, I am going to sell my t-shirt in 2000 rupees. So that is the counter. Which means offer against offer. I'm writing here offer against offer. And now coming to the last kind of an offer, that is cross offer, which means here Mr. A writes a letter to Mr. B about the proposal, and the same kind of a proposal has been sent by Mr. B to A, which means both are the proposal, there is no acceptance. Similarly, in counter as well, there is offer against offer. So any questions from the types of proposal here? Anyone who is still not clear with what is general offer, what is specific offer, what is counter, what is cross? Yes. In your comments, students. And if you are clear, then you will be able to answer this question, that is Carvel versus Carbolic Smart Ball. Okay, so the answer is, it is going to be considered as general offer, because the company has no idea now who is going to accept the general offer. So that is available for public at large. Coming to the next question, students. Who can answer this? And this is the question from the 2018 previous year question. In case if you are not able to read it again because of the size, I am reading the question so that you can understand it. Here is the question. Which of the following statements are true? Here are the statements. Statement number 1. Minor's contract can be ratified on attaining majority. Second, minor's contract cannot be ratified on attaining majority. Third statement, minor's contract can be ratified jointly by both the parties to the contract. Fourth statement, minor's not liable under minor's contract. And the last statement is, minor's contract is enforceable contract. So which are the statements which you think are completely correct here? Yes, waiting for your answer in the comments part. Okay, Shiv is the first one to answer. Okay, Shiv. Abhishek also. Okay, Atishay also answered. Diya. Okay, B. Durga, C. Okay. Okay. Now students, I'm also telling you, I'm also sharing some techniques which can be useful in your exam. Now there might be a situation for some students that they got confused about some of the statements, but for some statements they are sure that that is false or true. Now how to attempt that question? Now students, if you look at the fourth statement, the fourth one is minor not liable under minor's contract. I'm repeating myself. Fourth statement is minor not liable under minor's contract. Now we all are done with section 11. We all are done with the Mohiri Bibi case, which is, you can easily say that this statement is completely correct. There is nothing wrong in that. Which means if you are confused in all other statements as well, but if you know that what is section 11, what is the importance of Mohiri Bibi, then you must conclude that the fourth statement is true. And now if you are going to look at the options, even if there are 5 options, and yes, I hope everyone knows this, that it is only Haryana where you may again get 5 options as well for a question. But again students, if you know the answer, even in that case, if they are giving you 10 options, you will mark to the correct answer only. Now in that case, if you will look at the options, there is 4 only in this. There is no 4 in A, B, C, D and E, which means even if you are not sure about this, that minor's contract cannot be ratified on attaining majority, you can still choose the correct answer. Okay. Okay, sure. I'll try to zoom the question if I can. I'm extremely sorry for that students that I'm not able to zoom it, and I know that if you are not able to read it, it would be very difficult to answer it. But I can assure you from the next class onwards, the size is going to be big enough so that you can read it easily. Okay. As of now, I'm not able to do that. Okay. Or I can try something, but I can try something. Okay, let me try if I can do that. Okay, tell me, is it making any difference? Or is it the same? Because now I have opened it in the slide. Okay. Okay, don't worry, I'll speak all the questions, okay? And I'll be slow enough. It's okay. It's okay. Now coming to the next question, students. Okay, I got your response. Okay. Thank you, Kushi, Durga and Dia. Coming to the next question, students. Novation amounts to. I'm reading the question as well so that you can understand and you don't need to read it. Novation amounts to. First option, discharge of contract. B, formation of consideration. Third option is remission, and the last option is waiver. Yes. Okay, Abhishek. Got your answer. What about others? Okay. Correct. Okay, everyone is saying A, which means novation amounts to discharge of contract. So if okay, everyone answer is correct, then I don't think I need to explain the concept of novation here, right? So I'm directly moving to the next question because everyone's answer is correct. Yes. Yes, it's A only. Novation means discharge of contract. So let me give you a very basic example. If there is a contract between A and B, and the contract is A is going to sell some books to B and B is going to pay the price of 5,000 rupees. But after that contract, if both the parties A and B want to change some of the condition of the contract mutually, then in that scenario they can come up with a new contract, and in case of that new contract, the original one will be treated as discharge of contract, which means neither party nor A or B needs to perform the contract. Coming to the next question. Question number 6. This is also again from PYQ 2018 previous year question hai. Void agreements include first option students, agreements in restraint of marriage. Second option, agreements in restraint of legal proceedings. Third option, agreements with minor. And the last option is your D, that is all of the above. Okay, Aditya Mishra, first one to answer. 6D, okay. Abhishek, correct. Manjot Sidhu, D. Abhishek Shukla, D. Okay. Khushi, all above the above. Atishay, D. Yes. Okay, perfect. Then I don't think again I need to explain this. Void agreements, students. All you need to remember is void agreement is an important topic when it comes to your PT examination. You know, most of the chances that you will get 1 or 2 questions from this part. And void agreements start from section 23 till section 30. So these all points, agreements in restraint of marriage will be considered as void agreement. But mark it, students, that in case of agreements in restraint of marriage, there is one exception as well, which is minor only. Okay, so that is one exception, and in other cases that will be treated as void agreement. The next one is agreements in restraint of legal proceedings. There is no doubt about it. That is going to be treated as void agreement, and agreements with minor, again void ab initio. So the answer is all of the above. Coming to the next question, students. Yes, I'm reading the question in case if you are not able to read. The question is, a minor is, and the options are, I'm repeating myself, I'll be slow enough so that you can understand easily. A minor is, now the options are, the first option, not liable personally or through his estate. Second option, capable of ratifying agreements. Third option, liable for necessaries supplied out of property. And the last option is not permitted to plead minority as defense. Yes, students, answers now. Okay, I've got the answers. The first one to answer is Manjot Sidhu. Okay, then Aditya Mishra, Khushi, Abhishek Shukla, Atishay Jain, and Manjot again. Okay, yes. Okay, so let's make it a more difficult. If the same question has been asked to you at the time of interview, so how you can justify your answer? Yes, the answer is correct, that is C. So how can you defend your answer? So let's come to the next step, the next stage. Yes, I'll be super impressed if you can tell me the exact section numbers, that how you can actually defend your answer. Okay, Abhishek Shukla has answered section 67. Abhishek, close. Okay, you got it. That is section 68, quasi contract. Okay. Anyone else wants to try? The reasoning is correct, student. Chapter number 5 deals with this situation, and to be very exact, as far as this problem is concerned, that is section number 68. Shiv, this is not 67, the section number is section 68. Fine. Which says, the heading says, claim for necessaries supplied to person incapable of contracting or on his account. Kushi, you need to remember the section numbers because that are going to help you in your PT as well. Fine, they may ask you directly which section that is. Section based question you may get, and in your mains examination, if you are writing the answer on this, so that you will start your answer by writing this, that's section 68 of the Indian Contract Act 1872 and so on. Right? Yes, Durga Vyas, chapter 5, section 68. Okay, anyone want me to explain section 68 as well? In case if you have any difficulty with section 68, you may ask that as well. And if not, then I'll move to the next question. If not, then I can easily move to the next question. Okay, Abhishek is clear. Okay, Manjot. Okay, then if you have no doubts, I'll move to the next. Yes, students, this one. When consent to an agreement, I'm reading the question. When consent to an agreement is caused by misrepresentation under Indian Contract Act 1872, the agreement is, what is going to be the status of that agreement if it involved the concept of misrepresentation? The options are A, void, B, valid, C, voidable, D, illegal, and the last option is none of the above. Okay, I'm getting answers. Manjot first one to answer. C. Abhishek. C. Okay, Abhishek has also. Abhishek, please reconfirm section 18 or any another section. Harish Verma, C. Atishay, C. Okay, Khushi. Okay, everyone is saying C. Okay. Okay. And can anyone tell me the section number as well for that? Okay. There's a difference, students. There's a difference. Section 18 tells you misrepresentation. But where it is written that this would be considered as voidable. Yes, Durga and Abhishek. Section 18 deals with the concept of what is misrepresentation. But where it is written that if misrepresentation has been involved, that would be treated as voidable. Yes, now we are talking. Abhishek Shukla, correct answer, section 19. So you should know these as well. Okay. Section 19. Correct. So it basically starts from section 10, which use the term free consent, and when the free consent has been defined, it should not involve any coercion, any undue influence, fraud or misrepresentation. And if that is the case of misrepresentation, which is section 18 tells you what is misrepresentation, in section 19 they tells you that okay, these are the this is going to be the status that is voidable. Yes, correct. Anyone having any issues with these words void, valid, voidable or illegal? Because you are going to get questions like this in your PT examination. So if you want to ask anything, if you are not clear with what is void, valid or voidable or illegal, you may ask. And if no, then I'll move to the next slide. Shiv, please repeat, sir, to all. Which part you want me to repeat, Shiv? Which part? Okay. So I've got two questions, one from Shiv, who is asking about void, and Atishay is asking about the term illegal. Okay, I'm explaining, okay, voidable as well. Okay, so I'll quickly cover all these terms, students. See, void agreement. So the first important term is void agreement. If your question falls under section 23 till section 30, in any of these sections, the answer would be that it is void agreement. Fine. Starting from section 23 till section 30. Okay. Now coming to voidable. Voidable, there are section 19 and 19A. Now what is voidable? Voidable has the capacity to make it valid as well and void as well at the option of one party. Now which party? The party against whom the coercion has taken place. The party against whom undue influence has taken place. The party against whom fraud or misrepresentation has taken place. That party has an option to make that transaction valid as well and void as well. So that is the situation where we will fall voidable. So there are two important sections, students, section 19 and 19A. So I'm done with void and voidable. Valid, I hope there is no need to explain valid. If all the essentials are correct, if all the essentials of section 10 has been fulfilled, it will convert into a valid contract. Coming to the last term, that is illegal. If there is any unlawful activity, for example, if A gives a contract to B to kill C, fine, so that would be considered as illegal. Yes, students, this is the next question, and I hopefully the last one as well. Yes, this is the last one for today. The question number 9, a contract of life insurance is the nature of. So basically in this question they are asking you, a contract of life insurance is the nature of what kind of it is. First option, agreement by way of wager. Second option, quasi contract. Third option, contingent contract. Fourth option, gratuitous contract. And last option, none of the above. Okay, Aditya Mishra, first one to answer. C. Okay. Manjot, C. Abhishek, okay, everyone is answer. Abhishek, C. Durga Vyas, C. To answer this question, students, you should be clear with the concept of what is wagering agreement, that is section 30, and what is contingent contract, which is section 31. And yes, everyone's answer is correct, that a contract of life insurance is going to be treated as contingent contract. Anyone having any questions related to wager agreement or contingent contract? If you do have any issues related to these topics, you may ask, and if not, then I'll come to the next slide. That is the concluding one for the whole lecture. So these were all the important questions, and most of the questions were of your previous year questions only from the Haryana Judiciary. Okay, Aditya Mishra is asking, sir, can you please explain wagering? Okay, see, wagering comes under section 30. So let's take an example. You know, yesterday there was a match, India versus Sri Lanka, second ODI, right? Now in that case, Aditya and Sandeep both are watching that match, and suppose Sandeep passed a statement that, Aditya, will you do a batting here? In short, if India wins, you need to give me 1000 rupees, and if Sri Lanka wins, then in that case I'll give you 1000 rupees. Now what is this? This is an example of wagering agreement, which is as per to section 30 of Indian Contract Act 1872 will be considered as void agreement. Now in this transaction, Aditya, we are only interested in winning or losing, nothing else, nothing more than that. And that is why this will be considered as a void agreement, which means even in that case, if I won that bet, and if you, Aditya, say, no, I am not going to give you 1000 rupees, and I am going to file a suit on Aditya for breach of contract, that will not be treated as a contract, a valid contract. And if that is not a valid contract, it will not amount to breach of contract. Why? Because section 30 makes it void agreement. Void agreement means that has null, that is zero effects. Okay. I hope everyone is clear with this. What is wagering agreement? Okay. Now coming to the next slide, students. That is again important, the most important concepts on the Indian Contract Act 1872. This is completely on the basis of your previous year question papers of mostly all the states as far as your Indian Contract Act 1872 is concerned, which means the first section, section 1 to till section 30, the most important sections, from where if I need to tell you the exact sections from first 30 sections, please note it down. First one is your section number 2. They may ask you what is section 2A, 2B, C, D, where contract has been defined, where agreement has been defined, fine, where void agreement has been defined. So section 2 is very, very important. The essentials as well and the section number as well. Then it comes to section number 10. After section number 2, the most important section is section number 10, from where you will get the question. And section number 10 is basically which is giving weight to section 11 till section 30. Fine. After that, you must know the concept of contingent contract, section 56, section 62, quasi contract and breach of contract. And as far as after section 75 is concerned, the meaning of indemnity, where indemnity has been defined. What do you mean by this term indemnity? The meaning of guarantee, where the section number guarantee has been defined, the meaning of bailment and agency. These are the most important things, students, where at least 80 to 90% of your questions usually fall from these sections. But as a judicial aspirant, I always suggest you to at least go through with all the sections at least one time. These are those sections which you can go for revision multiple times. And this is completely on the basis of your previous year question papers. So you can please note it down, all these section numbers and concepts. Anything else, students, before ending today's class? Anything you want to suggest? One point I have already noted it down, that I need to make my the size of these words are going to be big. Okay, so anything else and any other suggestions? So see, students, this series is for you exclusively. So whatever suggestions if you want to give. Okay. Aditya Mishra is asking one question. Sir, can you please also tell about horse racing in reference to wagering? Okay. Aditya Mishra, answer to this question, if you are going to read section 30, you will find that this is one of the exception. Mind it, this is one of the exception of wagering agreement. Now the question is, sir, how this can be an exception? So to go for the real reasons, we have to really ask this question to the Sir John F. Stephens, who has drafted Indian Contract Act. So I have also searched about this answer, and the final concluding point which I have got from this statement, Abhishek, is that during that time in 1872, what was the situation in India? In India there were Britishers, and Britishers used to enjoy horse racing, so they could not make it illegal, or sorry, not illegal, they could not make it a void agreement. So that is the reason. I hope I am able to answer you completely, Aditya. Anything else? Or anyone else who wants to ask anything related to Indian Contract Act? Okay, you're welcome, Aditya. Okay, students, now I'm ending this session. So these are some important announcements here. Please do follow my profile. You can see the link here. Okay, with this profile you can actually get all the notice of about my special classes and the plus courses. You can also connect with me on my Telegram app. All you need to do is just open your Telegram app, and in the search bar just search Sandeep, SANDEEP, then only K for Khatri, and then UA is for Unacademy. So Sandeep KUA. If you are going to search that, you will reach to my channel, and you can suggest there that what YouTube sessions you want me to do, what special classes you want me to do on any particular subject or any particular concept. Okay, or in addition to that, if you are facing any issues, if you are facing any problems, you can write those problems in that group as well. Okay, these are my schedule of my upcoming classes. I've also started from today only a complete course on the law of torts as well, which I'm going to take classes from Monday to Saturday from 2 p.m. to 3 p.m. I'm going to cover all the topics of law of torts, all the previous year questions from Delhi Judiciary, from Bihar Judiciary and UP Judiciary. Okay, so my YouTube session is going to be now on regular basis. This was the first one, so this was also my first experience that how to teach on YouTube. So everything is new and I'm learning. So this is going to be from 7 p.m. to 8 p.m. from again Monday to Saturday, and my plus courses are also going on from 5 to 6:30 p.m. That is, right now I'm teaching Indian Contract Act 1872. So this was about me, and let's crack PCSJ with Unacademy. These are all the features which you will get. Learn live from the comfort of your home, unlimited access to all the courses, all the top educators of India under one platform, and then there's exhaustive coverage of syllabus, regular doubt clearing session students, which is again one of the most important thing for a judicial aspirant, live test series, study material, answer writing sessions. You can see all the subjects are here: contract, CPC, jurisprudence, all the subjects, even local law students. These are the current courses which are going on. These are the plus subscription, and there is one key which you can find: the more the months, the less the price. That's the catch here. And these are the handles, YouTube channel and the Telegram channel. That's it from my side. Thank you very much. Anything else, students? Okay then. Thank you very much. See you in my next class. Goodbye. Till then, take care of yourself. Peace.